Association of Law Libraries, 1983 Institute. Luncheon address, Marian G. Gallagher.
I'm just here to give your minds a rest from the subject. This could have been accomplished much easier day after tomorrow, by which time I may have discovered what is the subject from which I am instructed to ease your minds. I wouldn't want you to think I gave creative research no thought. I have given it some recently. And looking back on my 44 years, I can think of no person who applied creative research knowingly. Maybe we were doing creative research pre-CIS when we put together a legislative history, but at the time we didn't realize it. Research in the beginning was assembling the material to answer the question, no matter how ridiculous the question. The creativeness occurred usually at the end while trying to explain to some important patron that the authorities did not support his or her position. Well, I didn't spend too much time on that. I began to distrust my own observations early, so I went to the University of Washington reference librarians. They were of little help. One of them said, whatever it is, it can't be as bad as creative cataloging or creative shelving, which seems to bother them even more than the cataloging. Then I attacked it from another angle. Most law librarians enjoy research more than they enjoy budgeting. But once they get enough help, they have to give it up and assume the role of encouraging, prodding, and supervising others. I have not yet given up the role of observing, prodding, and encouraging students, but I haven't had any hands-on research for some time, except for myself. So I thought that I might have an easier time identifying creative research or creative actions that some of my students had undertaken. There's Roger Becker, now at Arkansas, who used to put watercolor landscapes on his seminar papers, bibliographies, order slips, and ledger sheets. He was heavily into sunsets, although they might have been sunrises. I never have been able to make up my mind. There was Mary Sanders, late of the California Department of Justice, but currently retired and a brown belt karate person, karateer. It could be that she's purple belt. It's not that I'm colorblind, I just don't have a very good memory. Mary, needing India ink to complete her graph of inflationary price increases, observed the need to stir the ink and did so by blowing into the bottle. we had to have the workroom ceiling repainted. Yeah, that's better.
It took me a long time to figure that out.
See what Penny did. I guess that is an indication of why I can't remember anything creative I did myself. Well, anyway, in the case of Mary, before that day, she had been a blonde. I remember that she also used to while away her time waiting for clerks in the local dime stores by finding a table of mouse traps and quietly and patiently setting all of the top layer. Never went past the top layer, but then there was Penny Hazelton, who organized her fellow students so that they actually followed her around for a calendar year and did what she said they should do when she said they should do it. Some of them didn't want to do what she said they should do, but she had another talent, and that was for persuading them that it was for their own good, and they always ended up convinced that she was right. I've been planning for a long time to find out how she did that. And if she hadn't told me many months ago that she didn't know what creative research is either, maybe now would be the time to find out. Then there was Earl Borgeson, whose time and motion studies, when he was a student, caused him to speed up our acquisitions procedures quite substantially. His process combined recording the checking in of a title at the same time one recorded payment of the bill, whether the invoice was there or not. Some of the dealers and publishers became a little testy when we kept sending their invoices back saying we've already paid this. But that's one good thing about law libraries. Everything always comes out all right in the end. By the time we figured out what was going wrong, Earl had graduated. As a working librarian, he actually stayed with us till somebody else stole him from the staff. But as a working librarian, his creativeness increased. At the University of Washington, his greatest fame comes from his efforts in extending, for all the campus, the Christmas holiday. The law library was to stay open until 4 p.m. on Christmas Eve, a silly regulation that clearly needed creative amendment. On Christmas Eve of that famous day, shortly after lunch, or maybe it was during lunch, Earl stirred up 3 or 4 batches of hot buttered rum in the photographic darkroom, which was in a position that all of the fumes drifted out through the reserve stack and into the reading room, which, as you know, on Christmas Eve doesn't have a lot of people in it. But the reading room, nevertheless, was a spot that fumes from hot buttered rum could bring the campus vice squad. Now we've reached the place at the University of Washington where hot buttered rum no longer is considered vice. But more important, the University of Washington no longer stays open on Christmas Eve and sometimes not on the day before. I did want to tell you about the Great Pigeon Race, but that takes a little longer, so Yep.
You have to go back to a great big.
All right, I know what. I'll leave out the message. Involved there were Jay Bartels and Mary Roop, who defected and became a children's librarian. And Mary Sanders was in on the great pigeon race. I'm sorry to keep telling you about the same people, but the farther away I get from them, the more creative they seem. That had to be in the late 40s or early 50s. Probably 50s, because Earl, was it before? Were Mary before you? Oh, so it had to be in the 50s. 6 members, between them, 3 of each, faculty and law librarians, bought a share in a pigeon egg. We paid $2 each and then waited eagerly and breathlessly for our eggs to hatch. We did not own the whole pigeon that hatched, and we did not feed them or nurture them, except that the night before the great pigeon race, I did keep them overnight. There were 7, I guess. Not how I ever got 7 pigeons from home down to the start of the race, I don't know. The interested owners of the various parts met in the law school quad at 6:30 a.m. because the racers had to be home back in Everett before their real owner went to work. Otherwise, we wouldn't know who won. He had a dog, but the dog was not very good at recording which pigeon came home first. There was to be a grand prize lunch for the winner on all of the losers. I do remember that Professor J. Gordon Gose's pigeon took off much faster than mine, which it should have because it was younger. I think it had to be younger because my pigeon was named Corpus Juris, and his was named Corpus Juris Secundum. And I figured that Corpus Juris's experience in trickery would help him to beat Corpus Juris Secundum. There were some other names. I think that Professor John Richards' pigeon was named Res Ipsa Loquitur, and somebody had a habeas corpus, but I don't remember who that was. And that's what comes from not writing things down creatively in 50-something so you can remember them in 83. As it turned out, we never did find out who won the race. The owner had told me not to let the pigeons go if it were raining, because pigeons don't like rain. They either go sit in a tree or they get plumb lost. And it had started to sprinkle, but I let them go anyway because I didn't know what we were going to do with 7 pigeons in the law library workroom until it was time for me to go home. Well, now this one has a message that it's not empirical research. It's not empirical legal research, but it's an example. If you give up too soon, because we never had another race, if you give up too soon, it's the same thing as being uncreative. Now that was supposed to be the end of the speech, but I forgot to bring the scissors and Scotch tape on the plane, so it's misplaced. I'm going on for a minute. I have to tell you about Al Coco, whose solution to the problem of scruffy little high school debaters invading his library to do their research on capital punishment was to collect all the materials on capital punishment, surround them with a plush, or maybe it was a velvet cord, with the entrance right in front of his circulation desk, and then announced to these youngsters that they would be privileged to have reserved for them the VIP lounge, ordinarily reserved for members of the judiciary. And then they all checked in very happily behind the velvet cord. And as they were registered, name, address, phone number, and fingerprinted, they were given a badge that had gold letters on it. And then there's U.V. Jones, ex-law librarian at Texas Tech, who was probably never got enough oral acclaim for the kind of reference librarian he was. And probably because I felt from the very first that UV was being helped a lot by his ancestry. And so I expected it of him. People used to ask us if UV Jones was his full name. And it wasn't, of course. His full name was UV Jones II. He had his grandfather had a number of sons whom he named A, B, C, D, E, F, and so forth, with a number of letters missing in the middle. And that's how come UV Jones got named UV Jones II. You have all heard of people who named their children by looking in the phone book. Here was UV's grandfather who named his children by looking on the backs of encyclopedias, and that's spine markings, I believe you call them now. That's why I figured he should be a natural. One last one, I remember that Sally Wise was a member of a class that they all liked each other tremendously. They did everything together. They would have been a commune, except that they didn't all live together, but they ate all their meals together. They rushed to the desk to help out somebody who got stuck shelving too many books. And Sally used her creativeness to recruit to that commune a children's librarian, a man who was studying at the School of Librarianship to become a children's librarian. So he would tell them stories. Kit Kralik was in that group. It's the only group of students I know that had a daily before dinner, an exciting story. Now, you might be wondering whether I wandered in here by mistake. You might be wondering whether I have a theme to pursue, and if any, what is it? I'm going to shorten it considerably, but I want you to know that it is not, quote, "You've come a long way, baby," unquote. I don't mind if it turns out to be that. I should like to be able to say, "You've come a long way, baby," but I haven't been able to make up my mind yet. And so I'm giving the problem over to you. I'll give you a number of instances from two sources. One was an institute for academic law librarians at NYU Law School in 1967. I have some minutes while I was shredding a few weeks ago. I found these minutes. The other is a committee report. I found that in the same batch. The committee report, it was a special committee to the AALL with the mission of telling the AALL what they ought to do to get ready for the computer revolution. It quotes a lot of computer experts long since dead, or at least burnt out. Well, first at NYU, we worried about our identity problem. When I began in this profession, it was more of an invisibility problem than it was an identity problem. Being a law librarian back then was about like being the editor of an encyclopedia. Not only had everybody never seen one before, but there was no recorded instance of any small child ever having said that he wanted to be one when he grew up. That really was quite evident. Didn't take me long to discover that. And it was demonstrated every time. It was demonstrated to all law librarians in those days. Every time we were introduced to one of those persons who wants to know what one does, or how one is, but what are you doing here? There's still a lot of those people around, and you meet them at cocktail parties. They especially don't ask you how you are, but they say, "What do you do?" And I learned a long time ago, very early, to answer distinctly with pauses between syllables. I am a law librarian at the University of Washington. If I said that to a professor from another department, say a professor of chemistry, he might say, I didn't know we had one. And one time I said it to a new member of the University Board of Regents, and he said, what would a law librarian do up there all day to keep busy? And when I said it to the traffic cop who was writing out my ticket, he said, how do you spell it? And, then I used to get some answers out of the city that were a little different. Right before the Huskies went to the Rose Bowl in probably 62, wasn't it, Earl? I was at an AALS meeting in someplace near Wisconsin because they were going to play Wisconsin. And when I said it to one of those Middle West professors, when he asked me the question, he said, is it really true that your quarterback has only one eye? And it was true. But it got good odds. I mean, you know, before going to the Rose Bowl, it was nice to get some nice odds. And I don't know if you'll understand this one, but there was another Middle Western answer. This would have been about 10 years ago. When I said it to somebody in the Middle West, that person said, say, I see where your whale died. And well, things that aren't quite that bad anymore. There are enough of you now that it's, every once in a while you run across somebody that knows what a law librarian is. But you can see that for a while in the state of Washington, it was a great temptation for me to go around telling people how it is with law librarians, because we discovered nobody but other law librarians knew how it was with law librarians. And part of the message that we gave them, because they asked, was, how does one become one? What is it like if one does become one? How does one prevent one's loved ones from making the same mistake? All right, at NYU in 1966, I'm going to tell you some of the things that we felt were deprivations visited on us because we were law librarians. And I think probably the identity problem had a lot to do with it. One, we decided law is the only field. This is out of the minutes, so the tense is wrong. If you want me to say law was the only field, that's what I want you to decide. Is it or isn't it? Law is the only field of human knowledge for which the Library of Congress has not provided classification schedules. Second, law libraries form the largest identifiable group about which no up-to-date information in statistical form is available. Law libraries outside of the federal government form the largest identifiable group of libraries which consistently have been ineligible for assistance through federal funding. Law is served by a high percentage, parentheses, probably the highest among all kinds of libraries, of personnel educationally unqualified, disinterested in modern librarianship developments, and unguided by standards or encouraged by knowledgeable patrons. That's the pits. Are you keeping track of these? Because you can leave the answers with Penny, whether we've got away from that or not. As a group, not just a group at NYU, but as a group, law librarians were smug, and we were aloof from what was going on in the library world at large. Our bibliographic control was superior, but that just made most lawyers feel they didn't need librarians. We had a lot of homemade catalogs. They were constructed by lawyers who never heard of tracings, for lawyers who didn't want to have to search a card catalog. I knew a homemade catalog once that the librarian said, lawyers don't like catalogs, so my staff is instructed to use only one subject heading, regardless of how many subjects the book's about. Julius Mark worried about what we called the new technology forcing us into control by central library systems. We worried about what we called the materials explosion. Make the publishers stop doing this to us, oh Lord, we said.